Bharatiya Nagrik Suraksha Sanhita. So if you understand a little bit about this Hindi or somewhat of Marathi, you would understand what these words mean. They are indigenous words. Bharatiya Nagrik Suraksha. The title itself of this new law is claiming to give you some kind of protection, and therefore it will be justified as you go along to various provisions which are there in this new law as such. So now, as far as this new law, the old one being Criminal Procedure Code, the new one being Bharatiya Nagrik Suraksha Sanhita, as far as this new law is concerned, you'll find there are changes made in the definitions also. This audio, video, electronic, this definition is there, section 21A. Then you see the bail, definition of bail is also, you'll find section 21B. Bail bond is also defined in section 21D. So also bond is defined in 21E. And also the much needed electronic communication, that is also defined in 21E. And I know you all may not be able to memorize the section numbers that I'm quoting, but then somewhere it will be helpful as we go along when we talk a little more about the section. It will be really useful to get to know what those sections really mean, how that terminology is really defined. Now, these new terms have been introduced, okay, and it reflects the evolving landscape of technology, when it comes to investigation, when it comes to trial, when it comes to court proceedings, covering various aspects of service of summons as well, of notices, of audio-video conferencing, for deposition of evidence, recording of search and seizure. All this got covered under this. This new definitions are really helpful to bring in all these new changes, which were much awaited and much needed changes, which have been brought about through this new law. Now there are procedural changes as well. As far as proceedings which are committed are concerned, they have to be finalized within 90 days from the date of taking cognizance. Cognizance is really you take notice of that offense and you initiate the process, and all it entails all that. Now this 90 days could be max extended up to 180 days, and also supply of copy of the police report to the accused and the victim within 14 days of the date of production or for appearance of an accused. That provision is also made. So accused gets a copy, victim gets a copy, they know what the proceedings are all about, they know what they're in for, so they are not ignorant about what is happening. So also section 37, subsection 7 of this new law, it prohibits arrest without permission of an officer above the rank of DSP. In cases where the offence is punishable for imprisonment for less than 3 years, and if the person to be arrested is an infirm or is above 60 years of age, then you need the permission of DSP, only then you can go ahead and arrest such a person. Under section 107 of this new law again, there is that attachment, forfeiture, restoration of proceeds of crime. All these things have been incorporated, they have been introduced in this new law as such. As far as use of handcuffs is concerned, that was felt necessary by the legislatures, and therefore a provision to that effect has been made in section 43, subsection 3 in this new law. And it is newly inserted to provide the use of handcuffs while effecting the arrest and production of an arrested person before the court for certain offences. Now this also can be justified. Of course, any law that I'm talking about, any new introduction, any change, you could argue both ways. But believe me, the intention of the legislatures is that all stakeholders should benefit, and the law machinery should work in such a way that there is justice done. That is the whole endeavor of incorporating or introducing these changes as such. There will always be a resistance to whenever changes are made. But as we go along, as the law settles, and if at all there are any challenges, there would be perhaps, those also would come. There would be ironing out of those creases by the judiciary from time to time, and that would take care of the law, whatever changes have come about. If at all there's any controversy raised about any provision. There is a provision about zero FIR also. Certain provisions are not new, they were always there. Earlier also, if you were to file a FIR in some police station which does not have jurisdiction, then they would have to forward it to the concerned police station. But conceptually those things were there. But now, in a formal way, they are incorporated. And by doing such a thing, by formally incorporating such provision, there comes about a lot of clarity, and any misconception around such concept, those get removed, and people would benefit from that. there may have been a reluctance on the part of the authority to register zero FIR earlier. That may have been the experience of some people. But now, this new law having made these things clear, I don't think anybody would dare to hesitate to take a FIR. Okay. FIR is just a first information report. It is setting the machinery of law in motion as such. No? And it is kind of a mandate given to the Law Machinery Enforcement Authority to register that zero FIR under 173 of this new law. Then there is a provision about mercy petition also. If you look at 472 of this new law, criminal law, this time-bound disposal of the mercy petitions in death sentences have been introduced. Now, I would go to the extent of saying it's not the right thing to keep somebody waiting forever and letting him not know his fate as to when he would be taken to the gallows. His mercy petition is pending and he doesn't know what is done to that mercy petition, when the mercy petition would be decided. But now with timelines in place, that is one new best thing, good thing that has happened with this new law coming in. There are timelines, within certain time something has to be done, and ultimately such matters get disposed of timely. That is again a good thing. He even looked at it from the accused point of view or the convict point of view as such. Then, as learned advocate, Advocate BHIMANI also said, there is this witness protection scheme also. No? There is this section 398 which allows or enables or empowers the state to come up with a witness protection scheme. How is this helpful? As of today, we are all aware that any of us, if we are called to give witness in the court of law, we will be the last person perhaps to volunteer or come forward and help the police machinery. With the result, if you don't have the right witnesses coming forward, those who have actually seen the offense or those who could help in the bringing justice, they may not cooperate, and then there would be that problem of delivery of justice. Now, if the state government, when it comes up with the right scheme, which would be allaying the fears of people, and thereby they would be encouraged to come forward as witnesses, that would really be a good thing as such. Then, as I said earlier, in that Indian Penal Code, the new law, Nyaya Sanhita, there also gender neutrality has been brought about. Here also, if you see, there was this phrase called some adult male member that has been replaced by some adult member for the purpose of service of summons. Earlier, one had to serve summons to adult male member only. That was really discriminatory and not the right thing perhaps, and that needed to be replaced, and that has been done with the incorporation of this section called Section 66 of this new law. Then you could say, with this coming of this new law, this procedure has met technology. Met as in, technology was going ahead, at a fast pace, and the procedure wasn't moving at that pace or coping up with the advancement of technology. That seems to have happened with this coming of the new law to a great extent. So, in order to ensure the use of technology and to bring about accountability in this investigation during search and seizure, what has been done is Section 105 of this new law. They have made videography of that process of search and seizure, including preparation of a list of seized items and the signing of it by witnesses, mandatory. Recently, I had one case where one lady was saying the police have not taken proper stock of the item that were there in a house, and some of it has got pilfered, and she was blaming everybody left and right. Now, all that perhaps would be settled with this coming of this new law when you have videography done also. Whether this is foolproof or not, that only time will tell. The other day I was discussing this provision with some colleague advocate, and he happened to say it also may so happen that they may visit that place beforehand, and they may put things in a certain order or tamper with the evidence, and thereafter the videography may happen. If at all any such things happen, then it is for the person who is defending that accused to bring it to the notice of the court, or the prosecution to bring it to the notice of the court, and the truth has to prevail. No system could be foolproof unless we cooperate, and I believe this incorporation of the new provision, like for example the videography and all that, has been done with good intention, and if we cooperate, only then this good intention will fructify, and we will enjoy the fruits of this good intention, and we will benefit, all of us as such. Then there were occasions where people would enjoy the proceeds of crime Now, in order to curb this practice, there is section 107, I would say. This is the new provision which has been added to enable the police, with the permission of the court, to attach and forfeit any property obtained as proceeds of crime. Now, this is not a blanket power given to the police. One allegation or one concern expressed by some section of the society, or some people, I would say, not sections, they would say that police are given tremendous powers. But there are checks and balances. It is not that they are given unbridled powers or unfettered powers and they can do what they want. It is not so. No, they were always subjected to the powers of the court, and that remains as such. So any abuse of powers, be it by any of the authorities, there are checks and balances, and that would continue to be there. Those checks and balances are not taken away as such. Okay. Person cannot easily get away with whatever he wants to do with the new provisions coming about. He cannot say now it has become much more easy for me to, do what I want. It is not so as such. That perhaps is a mistaken impression about this new laws. Then there were hierarchy of courts, or rather hierarchy of courts are there in provisions of CRPC. There are metropolitan areas, metropolitan magistrate, those things, metropolitan areas, metropolitan magistrate, that has been deleted from this new code. And section 2K8, 16, 17, 19, 355 and 404 of CRPC, they do not find any place in this new law. And this post of judicial magistrate of third class, then you have assistant session judge, those posts have also been done away with. No, they have been abolished. This has been done to bring about uniformity as such.